of the stakeholders qua implementation of the approved resolution plan. This is not a case where they're challenging the implementation of the resolution plan. They're challenging the process of selection of the successful resolution applicant.
With respect to that, my lords, the appellants in their appeal under 62 are challenging the 5th April judgment, that is the approval of the resolution plan that had been submitted by.
It has got nothing to do with the
implementation.
That's right.
Indeed not, my lords.
So this judgment does not apply then?
No, it does apply, my lords. Considering that approval of the resolution plan in that judgment, in the judgment which the council had just cited, it had
I think there are two interrelated questions here. It's approval of the resolution plan is one, but their eligibility to participate in the process was also questioned, which is an important question of law. And are you aware about our judgment in Glass Trust versus Baiju Ravindran?
Indeed.
What does it say?
With respect to Glass Trust versus Baiju Ravindran, your leadership, this honorable court had held authoritatively that there is no rigid technical or locus requirement with respect to the same. But it is pertinent to note the light in which Glass Trust was held, your leadership. With respect to the same, in that matter, the stakeholder in question was a creditor, your leadership. And he had a cognizable interest in the process. Now, they did not.
There's a difference, like my brother Jay rightly pointed out, there's a difference in the facts of this case also. It's about their participation in the process, which is getting restricted because of some decision that has been taken by the COC. Therefore, they are very much a person aggrieved, and this court should be able to decide on that.
Although it may, on the face of it, seem like they are an aggrieved person's leadership, it is to be noted that they should also satisfy the question of law, the component of section 62. With respect to the same, it has been held in a catena of judgments, especially SBI versus Murari Lal Jalan, wherein reference is placed on Chandravan versus Saraswati that talks about tests for determining a question of law. Now, to put it summarily,
what is that test?
The test is that whether for there to arise a question of law, your leadership, there has to be an unequivocal position of law and a derogation from the same, or a position of law that is ambiguous in nature.
It's good that you've raised this point. Are you aware about the Gulkrich judgment?
Your leadership, with respect to that, I feel like that burden is better placed on my co-counsel.
It's very much related. Maybe your co-counsel can answer, but it is very much related to the maintainability, because otherwise we'll not be able to. These two issues are interrelated. Can the NCLT could not have passed the order in this case to begin with against KCPL? That's the preliminary assessment that it appears, because that's the position of law laid down by the Supreme Court, that the third party, they cannot be in a direction, they can be a civil remedy. So that itself is interlinked with the determination under 29A.
With respect to that, your leadership, I will address that in a very brief manner, as the same will be expanded by my co-counsel. The holding of the court, honorable court, is that the related party is not a third party, as it is authoritatively held in.
That is not in Gulkrich. Are you referring to any other judgment?
Indeed, your leadership. The judgments the council is referring to at the moment is M.K. Rajagopalan versus Palnaswamy Gounder versus.
I'm glad, but that's not the relevant one.
And the same was referred in Phoenix Arc versus Paid Investments, your leadership. The same will be dealt with in detail by my co-counsel.
Then the issue of maintainability effectively remains open. He needs to club both of your arguments. Okay.
Indeed, your leadership. If this court deems it necessary, then it may do so. With respect to the question of law, again, there needs to be an unequivocal position of law and a derogation from the same, or an unambiguous position of law. Now, with respect to the questions of law raised by my learned opposite counsel, all of these have been settled authoritatively by this honorable court.
From where are you getting this unequivocal and unambiguous?
My lords, with respect to the same, the question of law, the test for a question of law was authoritatively held by this honorable court in SBI versus Murari Lal Jalan and Florian First, wherein they had relied upon a catena of judgments, including Chandraban versus Saraswati.
What was the composition of bench in Murari Lal Jalan?
I'm not aware, your leadership.
Is it a 6-judge bench?
So
then how is it authoritative?
It is authoritative in the sense that it is a Supreme Court judgment that.
But this is a larger bench. We can always consider.
Indeed, your leadership. However, thus far, it is the most authoritative judgment that talks about the question of law aspect of Section 62, wherein a comparison is drawn with Section 100 of the CPC, my lords, and how a question of law under Section 62 is akin to a second appeal. Now, if I may furnish a copy of the Honorable Court's judgment.
Let us come to the issues you have framed as a respondent.
Indeed, my lords.
Yes.
My lords,
Are they not question of law?
indeed not, my lords.
Let us read your issues.
Uh,
Let us read the issues you have raised.
My lords, with respect to the same, the main contention of the respondents here is that the questions of law or any questions of law does not arise from the impugned orders of the NCLAT as well as the NCLT, my lords. As in, the questions of law that has been put forth by the respondents in the present matter cannot be constituted as questions of law and should be seen as a mere attempt by the respondents to use 62 as a mechanism to go into the factual matrix of the case or re-examine facts or re-evaluate facts, my lords. And that is not the objective of 62. Now, the Section 62 cannot be used as a mechanism to make this Honorable Supreme Court a fact-finding authority, my lords. That is the simple contention of...
How do you deal with Regulation 36A?
With respect to Regulation 36A, my lords, the larger question with respect to that is whether adherence to these regulations are mandatory, not directory, my
Is
lords.
it not a question of law?
Indeed not, my lords. As for it to qualify as a question of law, it must be something that it should either be a derogation from a settled position of law or something that has not been authoritatively settled by this Honorable Court. Now, the contention that the Council is placing here is that
Has 36A been interpreted by us?
36A in specific may not have been interpreted, my lords. However, adherence to regulations is something that the Supreme Court has authoritatively adjudicated upon. And that is the same argument that the Council is going to put forth in issue 2, if I may go on with the arguments for why.
So we should adhere to regulation or we should not adhere to regulation?
It is directory in nature, my lords, that the regulation...
Who will determine that it is directory?
My lords, with respect to the same, this Honorable Court in Catena of Judgments has held directions to be directory in nature. My lords, it can be seen that Section 12, which provides for extension of the timeline or the outer limit of 330 days, was first
Over a question to you is
Indeed.
it not a question of law?
Indeed,
Whether
my
it is mandatory or directory?
It is directory, my lords, and that...
That is what you say, but it has to be determined.
Indeed, my lords.
How will it be determined?
My
Is it
lord,
a question of fact or a question of law?
indeed, the question, the nature of the question is a question of law, but it cannot constitute as a question of law as it has already been authoritatively settled by this Honorable Court.
There is a question of law, but because you say that it cannot be a question of law, that's why it's not a question of law.
Indeed not, my lords. My lords, the contention here is that this may obviously seem like a question of law, but what the Council is trying to put forth here is this issue of whether adherence to regulations is directory or mandatory is something that has already been settled by this Honorable Court. Therefore,
You are saying that every regulation under the sun will be directory.
Indeed not, my lords. What the Council is trying to put forth here is that in this present
So it
case,
has to be seen case to case whether it is directory or mandatory.
indeed, my lords, with respect to
So is there a case law as far as 36A is concerned?
my lords,
It is
with
directory or mandatory?
my lords, with respect to 36A, the specific adherence to 36A, the Council is not aware. However, the Council can cite cases wherein this Honorable Court has held adherence to regulations may be directory in nature and not mandatory.
So specific to 36A, isn't it a question that we determine?
Indeed,
So
indeed.
then it becomes a question of law?
Indeed, if the court deems it as a question of law, indeed it may qualify as a question of law. However, the contention put forth by the Council here is that the court, this Honorable Court, in multiple cases has authoritatively held that any procedural law must be viewed as a handmaiden of justice and not a tyrant of justice.
What was the reason that you went ahead with approval of one plan and did not invite competing bids or did not redone a process? Because if you have rejected one resolution plan, ideally, if the timelines would have permitted, you would have redone the process by issuing a new Form G. Why was that not done?
With respect to that, Your Ladyship, the if we look at this, the answers to this question can be found in the very objectives of the IBC leadership. Although the IBC provides for a time-bound process, one of the other, and again, as important, if not more important, objective of the IBC is the value maximization aspect of IBC leadership. Now, it is a
So
that's
value maximization So value maximization doesn't lead you to invite others, increase competition in the process.
indeed not your leadership. Obviously, in order to
It's an arbitrary decision making
Indeed not.
by the RP and the COC.
indeed not your leadership.
You have gotten only one plan. Why was no price discovery mechanism was followed where you did not invite any competing bids?
With respect to that, your leadership, a mere reference to the factual matrix in the proposition itself will reveal that the appellants in the present matter, your leadership, although I'm not referring to any specific lines here, however, I'm just generally perusing through the facts that the appellants in the present matter are the sole PRAs, my lords. So with respect,
There's a difference. In this case,
Indeed.
you received an unsolicited bid
indeed,
from a new resolution act.
indeed.
Fair. But why did you not? You should have ideally run a process where you invite competing bids. Because that would have been in the interest of value maximization and not this case. There is an arbitrary exercise by the RP and COC.
Indeed. However, the commercial wisdom of the COC is something that, again, the Honorable Court.
See, in other words, with the rejection of their resolution plan, one process came to an end. So
Indeed.
you should have started another process from
Through a
the
publication
EOI
of Form
stage
G.
and then invited everyone. It would have been an invitation in REM to
Indeed.
everyone, and that would have sort of helped you with the value maximization also. You never know, there was IUCL, there could have been another bidder also competing with IUCL. right?
Indeed, your leadership. With respect to that argument, in search of the most value maximizing resolution applicant out there, the CIRP cannot become a never-ending process.
You're appearing for the resolution profession, right? You're a court appointed officer.
Indeed.
You are making such submission that in terms of process, there should be strictures against you. There can't be a process. If we direct you to run a process, will you do that?
Indeed.
So we will ask you to rerun the whole process, invite new bids.
Your leadership, with respect to that, again, publication of Form G is again something that this Honorable Court is saying that is something that should have been done ideally, as that would mark the ending of a process and the starting of a new process, if that is
Yes.
the question. Your leadership, the simple contention of the council here is that irrespective of whether a Form G is published or not, the CIRP cannot be vitiated on the grounds that a Form G was not published. Considering that publication of Form G is something.
That's absurd. How can we not vitiate if a Form G is not published?
Your Lordship,
Are there any
leadership-
judgments to that effect?
Indeed, your leadership. However, it is a judgment of the NCLAT that the leadership, if it may be entertained by
You can summarily just state what the judgment says. Which judgment are you referring to?
M.K. Rajagopalan.
That is called a Supreme Court, no?
Indeed.
So you refer to the Supreme Court. What did Supreme Court says?
So what was held in the judgment with respect to the publication of.
The Supreme Court.
Indeed. What was held in the judgment with respect to the same was the publication of Form G was a mere procedural requirement, and derogation from the same cannot be said to vitiate
Can
the
you tell
entire
us which
process.
paragraph number of the judgment?
Indeed, your leadership.
And if you have your proposition table, maybe you can read out the paragraph.
Indeed. The council may just get a second to refer to. Your leadership, in lieu of the paucity of time that the council is facing,
That you understand the absurdity of this argument.
I do, your leadership. However, it has been authoritatively held by this honorable court.
No, we want to know because we don't believe that it has been held by even NCLAT.
Indeed, my lords. However, if the council may be allowed to furnish a copy of the judgment after having said the arguments, that would be better, my lord. Much
Then
obliged.
this is the second question that remains open.
Indeed, my lord. With respect to the same, the procedures under the regulations should be seen as directory in nature, my lords. Purely considering the fact that these procedures are simply existent to facilitate the entire process under the CIRP, my lords. And it should be seen as something that is facilitatory in nature. And strict adherence to the same will lead to the entire CIRP losing its process and losing the objective of the process of the same, my lords. With respect to the same, council would like to dwell more upon arguments with concerning the request for resolution.
Council, what objective are you trying to further when you are sort of, having picked up an EOI of an unsolicited bidder in a process which you are not starting afresh? Which is the objective of the IBC that you're trying to further?
Value maximization.
How is it value maximization?
Value maximization simply for the fact that if we consider the factual matrix in this present matter, it is not that there were multiple resolution applicants who were involved.
Moot court proposition doesn't even mention the value in IUCL plan.
Indeed.
How is it a value maximization case?
With respect to the same, your leadership, it is construed by the council as an attempt by the committee of creditors to provide a value maximizing outcome as well as the most important objective, which is the revival of the corporate debtor, your leadership. Now, if
you would have restarted the process, wouldn't it have led to revival of the corporate debtor?
Indeed.
Wouldn't IUCL would have come through the normal route? It was interested party, right? It had
Indeed,
given an
yes.
unsolicited EOI.
Indeed, your leadership, but there is
It would
also
have given a solicited EOI as well if you would have asked
Indeed.
for a EOI.
Indeed, your leadership. However, it is to be noted that such a possibility may also exist where IUL would not have bid or participated as a prospective resolution applicant. So there is a possibility that the CIRP could have become a never-ending process, your leadership.
What were the timelines of the CIRP that you're saying that it would have been never ending?
Your leadership,
You get 270 days in general, right?
Indeed, your
What
leadership.
was the timeline when the resolution plan of IUCL was approved?
Your leadership, we were well within the timelines,
Yeah.
right? Well within the timelines.
So it is not a case of time-bound, finishing the CIRP in a time-bound manner.
Indeed not.
So only value maximization is what you're arguing effectively,
Indeed.
without the proposition even saying the value in the IUCL plan.
Indeed, your leadership. Not just the value maximization objective. It is obviously connected to the ultimate objective of the revival of the corporate debtor. Revival of the corporate debtor is the ultimate
Without
objective.
even running a new process, you are concluding that there would have been no revival of the corporate debtor.
Your leadership, with respect to the same, I think revival of the corporate debtor again was the
At that point in time, what was the thought process of COC? Why did the COC feel that I should not go for an old process, I should not go for a new process and rather should just go and vote on the resolution plan of IUCL?
your leadership.
What was the value maximization that COC was looking at?
value
Or
maximization?
what was the logic or the rationale that COC had that this is the only chance of revival that the corporate debtor has?
With respect to the same, your leadership, again, value maximization, again, where there is no value, it may seem absurd that value maximization is being used as a grounds. However, it is to be brought before this honorable court that with each passing day, when the corporate debtor is still in moratorium and the assets still remain frozen, it is only natural that the prices or the value of the corporate debtor is about to go down, is going to drive down. And with each passing day, the value that the corporate debtor has would erode naturally.
See, without a value determination process, you cannot conclude that with each passing day, the value will go down.
Indeed,
You cannot say that.
indeed.
Does COC have anything on record to say that with each passing day, the value would go down?
Indeed not, your leadership. That would be one part of my argument. The second part of the argument would be that the COC is empowered to do so. Under the large vested power that it has with respect to the
So
request for
nobody is
resolution
denying
plan.
that. The COC even has a power to not run the resolution process. It can straight away send the company to insolvency, to liquidation, right? But that does not mean that when you run the process, you don't run it within the act and the regulations.
Indeed.
If you decided to invite resolution plans, then you've got to follow the regulations.
Indeed, it did follow regulations, my lords. With respect to the first, CIRP had proceeded on 13th October, and then there was a Form G issue on 11th December of 2024, and 24th February was set.
Then you did not follow the process
We did,
after doing all of that.
your lords, my lords, with respect to the same, the only sole prospective resolution applicant was stood disqualified by a 66 order, my lords. Now, when the only prospective resolution applicant, after having done a Form G publication, trying to find expressions of interest, and after having entertained prospective resolution applicants, singled down to a single resolution applicant who turned out to be fraudulent and was disqualified. Council feels that the committee of creditors are well empowered within the authority that has been conferred to them under 36B in the request for resolution plan. Again, the request for resolution plan is in compliance with the regulation 36B, and respondents, my apologies, appellants have been in compliance with the same. They have agreed to this. They have subjected themselves to this RFRP while agreeing to be part of this resolution process. So when, my lords, when
You raise a very interesting point. Is RFRP the law?
indeed not,
It's something that has been curated by the COC,
indeed,
right?
indeed,
And there are precedents to that effect.
indeed.
So basically, if there is an inconsistency between the provisions of the RFRP and the regulations, what should prevail?
The regulations,
And so
You've
says your
answered
RFRP also.
indeed,
So you've answered the question, right? You should have, ought to have complied with the regulations, issued a new Form G, which you've not done.
with respect to the same, council's simple argument is that issuing a Form G and going about it would mean to start from scratch, your ladyship. And that would again mean a lot of time wasted for the corporate debtor and a lot of delay involved in reviving the
So
corporate
you
debtor.
can arbitrarily choose which.
Indeed not, your ladyship.
That's exactly what has happened here.
Indeed not, your ladyship. With respect to the same, again, one of the few grounds that remain to challenge the commercial wisdom of the committee of creditors is manifest arbitrariness or patent illegality, where there's been a complete derogation of the code, your ladyship. The council is not denying that. However, the use of discretion by the committee of creditors in this
You
matter.
need to understand, we are not on the viability of the plan.
Indeed,
That is for the COC to decide.
indeed,
We are on the point that whether you could have entertained the plan.
indeed.
So the test that you have just cited, that will not apply to the question that we are determining here, whether you could have entertained the plan or not.
Indeed, my lords, with
Because it
respect,
has to be, whether the plan has to be entertained or not, that is not commercial wisdom of COC.
indeed, my lords, with respect to the same, the question here is whether a derogation from the regulation is allowed or not. That is the simple question here. And the council is trying to put forth that the derogation that has been done in the present case from 36A is something that is good in law and is done within the ambit of authority that has been conferred to the committee of creditors, my lords. That is the contention of
And what is that authority?
the authority given by the RFRP to the committee of creditors.
We are citing your provision.
Indeed.
You please cite us provision or some case law.
My lords, with respect to the same regulation 36B, my lord, gives powers to the committee of creditors with respect to a request for resolution plan, my lords, wherein a new request for resolution plan may be issued, and in light of the resolution accepted, the received resolution plans being unsatisfactory in nature, my lord.
But you did not issue the new RFRP.
Indeed, your
You
ladyship.
gave the same old IM and RFRP to
Indeed, your
IUCA
ladyship.
and moved on with the process.
Indeed, your ladyship.
Yeah.
With respect to the same, again, council is trying to put forth that this is done in lieu of, again, the value maximizing argument that the council took is not just with respect to the value of the company eroding, but the time taken in the process. Again, we may be well
Can
within the
you
time, but
come to paragraph 41 of your submission, written submissions, paragraph 41 at page 27.
Your leadership, page 27.
Page 27, para 41.
Indeed, Your leadership.
Now read starting from paragraph 4 clarifies that.
Your leadership, is this with regards, this is a written submissions of the respondent.
Yes,
Paragraph 41.
yes.
The factual record indicates that after submission of IUEL's plan,
I am reading page 20, you're on page 27, right?
28, my lead, Your
Page
leadership.
27.
Para 41.
41 is paragraph.
The jurisprudence of CIR.
You can have my copy.
The jurisprudence developed under the Insolvency and Bankruptcy Code 2016 consistently recognizes the dynamic and evolving nature of CIRP. The code does not envisage a
Read the underlined part, paragraph 4,
The para above that.
para above that.
the underlined part, paragraph 4.
The COC has resolved within time. The adjudicating authority may allow extension even beyond the statutory period to ensure that the resolution process is meaningfully
So
completed.
it's very important. You highlight and you agree to the fact that for a process to be meaningfully completed, you could have approached the NCLT.
Indeed.
You could have asked for extension of
Indeed.
time and run a process in a transparent manner, giving others an opportunity. But you did not do so. So clearly there is an arbitrariness here, and we are willing to consider the argument advanced by the appellant in this case.
Indeed, with respect to that, indeed, the leadership, if the honorable court feels like there is a question of law involved or if there is a tinge of arbitrariness involved, it may, again, if it may use its discretion to examine the same. However, the simple contention of the council here is that there is no sense of
Which
arbitrariness.
section of IBC deals with timelines under the IBC?
With respect to the same, there are, I'm not exactly in specific with regards to what, my lords.
The time frame under the IBC.
Time frame is given, the model timeline is given under regulation 40A, my
Not
lords.
the timeline. The time frame to complete the CIRP process. Which section deals with that?
Section 12, my lords, wherein an outer limit of 330 days have been given. And obviously it is amenable to exceptional circumstances.
Did you calculate how much time was exhausted in your process?
My lords, it is well within the outer limit, my lords.
Don't say well within. Have you calculated the time? Was it within the 180 days?
It is.
Or was it within the 270 days? Or was it within the 330 days?
With respect to the same, I think it is in approximately close to 180 days, my lords. When the new
Is there a provision in section 12 where you could have gone and got an extension?
Indeed, my lords, the extension is something that was amenable, that was an option to the committee of creditors, and they could have issued an extension. However, it had used its discretion to entertain an expression of interest, my lords.
To entertain an unsolicited expression of interest.
And indeed, my lords, the expression of interest was good in law and
It was unsolicited.
unsolicited in the
The
sense.
issue says, even the issue that you have framed, you have used you yourself have
Indeed,
used
indeed.
the word unsolicited.
Indeed, my lords, with respect to the same, unsolicited in the sense that it has been entertained without a publication of a form.
Can an unsolicited resolution plan be entertained by the COC?
Indeed, my lords.
Is there any case law which helps you?
With respect to the same, my lords, again, the council was trying to prove that the directions, the guidelines
The
given
question
under
is there a case law which helps you?
a specific case of
As
no,
far
my
as
lords.
entertaining an
Indeed.
unsolicited resolution plan is concerned.
Indeed, not, my lords. The line of argumentation that the council is trying to take here is that the provisions, the very regulations given under the IBC are directory in nature, and therefore derogation from the same should not be considered fatal.
I think you are contradicting yourself. You say that there is the timelines are directory in nature,
Indeed.
but still you did not approach the court. So you did not seek additional time so that you could run a transparent process where you could give an opportunity to the other interested applicants. You did not do that. But when it comes to 36A, you're saying that's directory in nature. So I'm not able to understand why there is such a distinction between you're basically self-contradicting yourself in different stages.
The leadership of the council does not see the contradiction. However, it is to be noted that the derogation from the timelines was again in lieu of revival of the corporate debtor. And I would like to rest my arguments there if the honorable bench may have any other questions that the council may clarify.
Thank you.
Much obliged. It was an honor arguing before this honorable.
Permission to approve the minutes.
Permission to collectively get to the bench of Manoj. Much obliged, Manoj. Manoj, are we reading issue number?
We are still open on the question of maintainability,
Indeed.
so we'll just answer that first.
Any Manoj. Manoj, the burden that I take for the related party transaction, Manoj, for the same, I'd like to present the case of M.K. Rajagopalan versus Dr. Palyaswamy Palani Gounder, Manoj. Manoj, it is this case, along with the case of Phoenix Arc versus Spade Financial, Manoj. What is important to note here, Manoj, that in both of these cases, and rather, Spade Financial is the one who put forth the assertion that a related party shall not be allowed to
Spade, the question of law in Spade was not in the context of
Indian
66.
Manoj. Indian Manoj.
Okay.
What the court went on to observe in the same case, Manoj, and it highlighted in the same judgment, where the court first said that a related party cannot be involved in a section 21 clause 2, Manoj, which is in the committee of creditors. Then the court further went on to hold that they cannot also be a resolution applicant and they're barred under section
That's fine.
29A.
These are settled positions, so we're not going there.
Indian Manoj. So that is the essential part where, because a related party, and the court further holds in that case, as well as later in M.K. Rajagopalan,
No,
that there
I
be a
am talking
separate.
about, okay. I don't think the two judgments that you have just tendered to the bench are relevant. Let's talk about Gulkrich.
Indian
Right.
Manoj.
What is the position that is laid down in that judgment? What is the
Manoj, so this honorable court in Gulkrich holds that section 66 applications cannot be made against third parties, which is to say that the directors and the promoters may be
So
included.
therefore, clearly the adjudicating authority could not have passed any directions, therefore they were not ineligible under 29A, so to say.
Indeed not, Manoj. And if I may get an opportunity, Manoj,
Yeah,
to
yeah.
explain the case.
No, sure. No, I'm just saying, I'm just setting it out because don't go into the line of argument for Spade.
Indeed, Manoj. And if my lords may entertain the line of argument for Spade, my lords, that will answer my lord's question. My lords, both these cases, M.K. Rajagopalan and Spade, further hold that a related party is an extension of the corporate debtor, my lords. It is a class unto itself and it cannot be equated as a third party, which is the essential position why.
So show where
Indeed,
it
my
is.
lords. So the judgment that was just tendered, my lords,
Read out the paragraph.
one of this paragraph number 54 of the same judgment, and which is later also affirmed, which affirms Spade Financial, my lords, under paragraph number.
Are these judgments applicable to MSME?
My lords, they would stand applicable to MSMEs because the question is not whether.
There are specific exemptions for MSME.
Indian, my lords, and we're not contending section 29AC in this case, nor are we contending a section 29H to be applicable in this case, my lords. So once both of them are out of the question, the judgment will continue to apply to MSMEs. My lords, with regard to the question for Phoenix Arc, my lords, we see the M.K. Rajagopalan judgment that have been tendered also discusses MX Phoenix Arc, my lords, and the Phoenix Arc judgment provides in paragraph number, my lords, under page number 136 of the compendium that has been tendered, under paragraph number paragraph number 94, my lords, where it discusses section 21 clause 2, and later on it goes on to discuss section 29A. My lords,
I think I want to know, you can read out, if you have the copy, you can read out the part where you're saying that related party is not it cannot be equated with a third party.
Indian,
That's
my
your
lords.
submission, right?
Indian, my lords.
Yeah, so let's see that part.
My lords, apologies for not having.
That is okay.
Thank you.
Maybe your team member can check, but this is very
Anyone.
important because if
I understand
Yeah.
the consideration that my lord is making, and that's essentially why I tendered the judgment, my lord, where that judgment
but you've not
specifically.
shown anything to me yet, at least I don't have.
My lord, the judgment has been
No,
tendered.
we want you to read that para.
Indeed, my lord, then I shall, my lords.
We might not
No,
have the
you can
copy, but we can hear that para,
Indeed, my lords.
because I've been waiting for that para.
So, my lords, under paragraph number 54.1, the court provides that after taking note of the fact that related party is prohibited to be part of COC and is further prohibited to be a resolution applicant or authorized representative, the tribunal and then the court reaffirms the order of the judgment of the tribunal, where it says that the appellate tribunal proceeded to observe that related party was required to be equated with the promoters as equity shareholders, and then further made certain observations and discrimination between related party unsecured financial creditors and other unsecured financial creditors, which, my lords, goes to say that a related party is a further extension of the corporate debtor itself, and that's why it does not amount to a third party under Gladfritz, my lord. Say if it was another person, not a related party, then they could not have been made a party to this case, my lords, and then further civil courts should have taken up remedies against them, my lords. But the mere fact that related party brings them under the ambit of being a further extension under the judgment of other two judgments rendered, my lords.
As part of Gulfridge, is there any distinction made? Because I have Gulfridge, and I'm just reading out one paragraph. It says that we have the considered opinion that in circumstances so and so, the remedy against third party, however, is not available under 66 of IBC. That's the
Indeed, my
ratio.
lords.
Now, if that is the ratio, there is no exclusion for related parties. At least that's not what I see.
In my lords, in furtherance of the same, my lords, that would be present if the person would not be a related party. My lords, if we look at the Gulfridge judgment in light of these two judgments,
That's a new interpretation that you are giving. That's not what the law today says.
my lords,
You want us to distinguish that today.
my lords, it would not, so to say, be distinguishable right now, my lord, rather affirmation.
Is there any judgment which has distinguished Gladfritz as far as related party is concerned?
Till now, my lords, Gladfritz has not.
Even of the tribunal, is there any judgment?
Till now, my lord, Gladfritz has not been reinterpreted in any other case.
Have
My lords,
you read Royal India Corporation of the NCLAD?
indeed, no, my lords. My lords, but the essence of the argument still remains, my lord, that the related parties are deemed to have certain information about the company, my lords, and that is why they're a separate class unto itself. They cannot be equated with third parties. They're an extension of the corporate debtor themselves. If my lords are satisfied, I would move on to my particular issues with regard to issue 3 and issue 4, my lords. Much obliged. Now, it is our contention that the direct diversion of the sale consideration that took place when reference is made to clause 12 that is provided in the proposition, where the corporate debtor and KCPL in this case enter into a transaction where all of the consideration is directly and personally paid to the promoter.
It's all right. Go ahead.
It's provided to the promoter, my lords. Now, my lords, this is very essential when we look at the entire nature of both the parties that are involved here, my lords. And both of these parties are related parties. Now, my lords, before I divulge more into that, if my lords' attention come to page number 109, in the case of NK Power Infrastructure versus Nanda Rangsam Marak, my lords, where essentials of section 66 clause 1 are provided, my lords. The first condition is liability can be fixed upon any person, including but not limited to the directors, my lords, which is clear when we examine section 66 clause 1, which provides any person and not just directors, because directors and promoters is specifically provided for in section 66 subsection 2, my lords. My lords, then this would mean that the international and national jurisprudence on this stands on whether or not other parties other than the corporate debtor and its promoters can be involved in section 66 subsection 1 transaction is very clear in both national and international jurisprudence. Well, if we were to look at international jurisprudence, we have on page number 99, my lords, two cases of the UK court, Ray Augustus Barnett and Son Limited and Ray Gerald Cooper Chemicals Limited, my lords. But the court holds that when we examine fraudulent provisions and persons and parties which are included, and my lords, it may be noted that sections of the IBC have also taken their legislative ancestry from the sections of the insolvency law from UK, my lords. And in this particular case, section 230, my lords. The court holds that
No, UK law, does it say that it's applicable? What is the difference? There's a difference between UK law and 66 and what is it?
Indeed, my lords. My lords, in regard to the same, what is to be noted that the court in this very specific provision, my lords, holds that any party will include not just persons who carry on the business of the corporate debtor, who assist the business of the
You can't
corporate
apply
debtor.
that position here because here, like I said, there's a distinction. So at
Indeed,
least when
indeed, my
insofar as
lords.
this court is concerned, I don't think Augustus is applicable in this case. Okay?
My lords, when we see the case of the NCLAT and Sanjeev Kumar Bhardwaj versus Ghanshyam Das, my lords, the court holds that, the appellate tribunal holds that persons who knowingly parties to the carrying on the business for fraudulent purpose shall be responsible without any limitation of liability, my lords. This case, essentially, the appellate tribunal took consideration of Reza Lord Kupal, my lords, and then gave the finding that there cannot be any limitation of liability. Now, this limitation is to be construed in the way that there cannot be any protection or shelter that can be taken on the mere fact that they may not be part of the company, my
Now,
lords.
in this case, factually speaking, what was the market value?
1.95 crores.
What is the transaction value?
2 crores, my lords.
So insofar as KCPL is concerned, they have discharged their obligations, they've made certain payments. What is the relief that can be granted against KCPL?
My lords,
At the NCLT level, what is the relief that was sought? Do you have that as part of your proposition?
my lords, what relief was sought is not part of the proposition. Rather, my lords, what we do contend before this
So
honorable
what was the relief that was granted by the NCLT in this case?
My lords, the NCLT held KCPL as well as Arun Valmera jointly and severally liable under section 66, my lords.
Okay. So what would be the joint and several liability?
My lords, to pay rupees 2 crores
He
that
has
was
already
taken.
paid that part.
My
He's
lords,
already out of pocket, right? He can't be asked to pay again.
my lords, in respect to that, just because someone has benefited from a wrongdoing, that does not mean
No, no,
that
come on. Let's play out factually. Here he's out of pocket to the extent of 2 crores. Who can you ask that the money be paid back to the kitty of the corporate debtor?
my lords, so the order cannot be applied retrospectively to say that since he has already
Question
paid
is
2
very
crores.
simple. Here in this case, KCPL has already discharged its obligation. They have paid something which is over and above the market value. Even hypothetically assuming that this is a fraudulent transaction, which we are not ruling on, but he has paid certain amount which is above market value. It's very important, right? He has paid that amount. Now, who can be asked to pay that money back?
No.
The direction is not for returning the property back to the corporate debtor. The direction is to get the money back.
Indeed, my
And
lords.
that money direction can be against who?
My lords, although the council understands my lord's consideration that because KCPL has already allegedly discharged its liabilities to pay the 2 crores in consideration, that only Mr. Arun Valvera may say, so to say, we made responsible to pay for this consideration, my lords. My lords,
In
it is-
that case, full 29A we apply.
Indeed, my lords, it will still apply. And that is the essential position that the council is contending, my lords, divulging into issue 4, that Mr. Arun Valmera has not approached this court for an appeal with regard to this position, my lords. So the order of the NCLAT holding him liable for a PUFE transaction, which in this case, my lords, a fraudulent transaction, still exists. And it's an admitted position in this case that KCPL and VLPL are related parties, my lords, and it's provided in the very proposition, my lords.
Oh, one more interpretation for it. I don't need that. Come to 29A.
Anyway. Anyway.
Read the first line.
A person shall not be eligible to submit a resolution plan
No,
if such.
29A G.
So a person shall not be eligible to submit a resolution plan if such person or any other person acting jointly or in concert with such person has been a promoter or in management or in control of a corporate debtor in which a preferential transaction, undervalued
So
transaction.
the threefold test is what? He has to be either a promoter or
Indeed,
management or in control.
Indeed, my lords. So, my lords,
Does KCPL meet any of these criteria?
my lords, so we must look at section 29AG through the lens of section 29AJ, my lords. And my lords, I will prove that first, and then I will come back to proving the subsistence of 29AG alone, my lords, independently, even without looking at section 29AJ, my lords. If you look at section 29AJ, it gives out conditions of who may be connected persons, my lords. And the third point under that is a related party, which in this case is an admitted position. Now, if a related party of the resolution applicant, my lords, has been involved in any fraudulent transaction, that will rule out the resolution applicant from being allowed to continue in this resolution plan in the first place, my lords. So section 29AG is satisfied when we look at it through the lens of section 29A(j), my lords, under point number 3.
There's an exception, right?
Indeed, my lords, the exception.
Exception.
So, my lords, the exception is that if anything has, or if this transaction has occurred before the resolution applicant has acquired the said commercial debtor, my lords. But another proviso to that very proviso, my lords, is that they should not have contributed to it.
No, related party. For the definition of related party,
Indeed, my lords.
there is an exclusion, right? Have you read Swiss Ribbons?
Indeed, my lords. And I understand my lords' consideration in terms of the business activity point that my lords is making, my lords. That is essentially why I go to say that section 29A(g) and section 29A(j) subclause 2, my lords, will both be proved independently. If my lords may make a notice of the case of Asher Mithal versus Satish Kumar Gupta, my lords, found on firstly on page number 48, where the code provides that section 29A would be a see-through provision, which would allow us to look into it, my lords. And secondly, my lords, if we look at the definition of acting in concert, where this court uses SEBI regulations, particularly subregulation 2, my lords, to define what acting in concert means. My lords, under this subregulation, it means, so if I was to read the subregulation, my lords, it provides that regulation 2(1)(q) of SEBI, substantial acquisition of shares and takeover regulations 2011 for construing the expression of person acting in concert. Subregulation 2, my lords, without prejudice to the generality of the foregoing, the persons falling within the following categories shall be deemed to be persons acting in concert with other persons within the same category. And my lords, under that, point number 5 is immediate relatives, my lords, which in this case is a promoter of the corporate.
They don't have any business relation.
Even if they don't have any business relation, my lords. And this point was again reaffirmed, my lords, because we are not looking at the business relation from the point of a related party, my lords.
Have you seen the case laws on the interpretation of person acting in concert?
Indeed, my lords. My lords, with respect to the same, if we look at this in light of holding in Phoenix Arc, where, my lords, it looked at both the collusive nature of agreements that were rendered by two parties, my lords, Mr. Arun Anand and Mr. Anil Nanda, my lords. It held that because both of these parties were under the ambit of related party transactions, my lords, the court held that agreements entered into by them would be collusive in nature. My lords, if we go further, the court also held that the mere presence of the resolution applicant's son being there, my lords, as a related party, that itself, my lords, brought it under the purview of acting in concert, my lords. So the application would remain the same, my lords, if my lords are satisfied. Further, my lords, it is important to note and reference be made to page number 7, my lords. Paragraph B, scope of work, which effectively provides that the documents that have been perused are audited balance sheets of VLPL for the past 25 years, bank account statements from VLPL, all ledger accounts, commercial agreements, bank accounts from the promoters, and other documents, my lords. So to say that the transaction audit report cannot be a considerable piece of evidence in this case would not be a good position of law, my lords. And this position,
Paragraph 7 in that case.
indeed, my lords. Paragraph number 7, my lord, would say the RP filed an application on 28th.
Move proposition.
Indeed, my lords.
While the transaction appears to have been undertaken, just for the disclaimer.
Of the TAR.
Indeed, my lords. While the transaction appears to have been undertaken at an appropriate market value, and while it is also recorded that VLPL owed 4.5 crores to Mr. Arun Valmera, the direct routing of consideration to him gives an impression that the sale deed dated 5th April 2020 may require scrutiny as a potentially fraudulent transaction.
What is the requirement that the RP supposed to do? RP supposed to make a determination. It says it's not conclusive in nature. It says may require scrutiny as a potentially fraudulent transaction. What was the scrutiny? Did you do any further scrutiny?
My lords, so this, the paragraph number 7 that my lords has taken consideration of is from the transaction audit report that is not prepared by the RP, my lord. After this transaction audit report was rendered on 15th April, the RP did make a consideration and then file an application towards to the adjudicating authority.
What does the JP judgment say about the RP making a determination?
My lords, it provides that the RP cannot decide whether or not it was a related party
He's
transaction or
supposed to
not.
form an opinion.
Indeed, my lords, and that is essentially what has been done in this case, my lords. We see this from the fact that KCPL was allowed to continue by submitting to getting to the point where they submit a resolution plan.
But it ties in with the previous point that he has already paid his obligation, which is as per the market value.
Although I understand where my lords is coming from. My lords, if I were to answer this in twofold. Firstly, my lords, that the RP allowed the continuation of KCPL because the RP could not make a judicial determination, in which this case it has not, my lords. Only after the judicial determination came from the Honorable NCLT is when the disqualification under 29A came. My lords, in terms of, my lords,
It's very strange. You got an opinion from one auditor who has not given you a conclusive opinion. You approach the NCLT, you let them make the determination. In between, you are just acting like a courier.
my lords,
Right? You're not making a determination because you're saying, I can't form an opinion. I'm giving it to the court for them to make an opinion. They are making an opinion based on a audit report which is not conclusive in nature. At the same time, you are giving a backdoor entry to a resolution applicant who has submitted an unsolicited bid, and like what we were saying earlier, that unsolicited bid has been arbitrarily considered by the COC.
indeed not, my lords. If I be allowed to make a slight disagreement with my lords, in a very particular case of the NCLAT, a similar issue was in question, my lords, and the judgment is tendered, Rana Sarkar versus Bimal Agarwal, my lords, where similar facts and circumstances in terms of existence of documents by which the RP formed an opinion, which my lords it also has in this case. My lords, where the bank accounts were present, the sale transaction was present, and the written submission of the appellate was present, my lords, in front of the NCLT. And my lords, from this, so before this happened, the RP formed a view that this was a fraudulent
Where
transaction.
is the intent to defraud?
Right, my lords. If my lords may allow me, I would finish the question that my lords
you
is
take
first.
it up. You take it up.
Indeed, my lords, if that may be the case. My lords, it is very pertinent to note here that both of these parties are related parties, which means that they, according to the legislative note, my lords, which is also tendered here, my lords, that the parliament themselves provide, my lords, that insiders are deemed to have intimate knowledge about the companies, my lords, in terms of financial knowledge. So, my lords, them being a related party.
Let us assume that KCPL also had the knowledge. With
Indeed, my
the
lords.
intent to defraud.
Indeed, my lords.
Fact remains that a sum of 4 crore 50 lakh has come from the account of Mr. Valmera to the corporate.
Indeed, my lords. My lords, to answer that in twofold. Firstly, my lords, although the money was paid by Mr. Arun Valmera, my lords, that is not a point of contention in this case. Rather, it is choosing one creditor who is, first of all, an unsecured creditor, my lords. So, Mr. Arun Valmera understands that there's an impending insolvency that is to come, my lords.
How does it make a fraudulent transaction?
Indeed, my lords. So, when we consider this in the backdrop of what would happen if Section 53 would be applied, he would not have received practically, my lords, any money
That's
after
a
that.
determination from Mr. Valmera. That's a distinct transaction, right?
Indeed,
We
ma'am.
are okay to consider that Mr. Valmera is responsible because he was made. So let's keep that aside for a moment. But here in this case, you are targeting an entity which has duly paid its obligation. You're saying that they are supposed to be disqualified. It does not sound correct.
My lords, for the reference of the same, if we read section 66, my lords, it provides two conditions, my lords. Firstly, the activity should be done either with an intent to defraud the creditors or for a fraudulent purpose, my lords.
What does it mean when you say it's intent to defraud? How do you establish that?
Indeed, my lords. So, as my lords have already considered that the acceptance of intent to defraud from the part of Mr. Arun Valmera is present here, my lords, as my lords put forth. My lords, in lieu of the same, when they are...
That's an account of Mr. Valmera. Let's keep that aside for a moment.
Indeed, my lords.
Where is the intent to defraud for KCPL?
Indeed, my lords. So, in light of the same, my lords, if KCPL, being a related party with intimate information of the financial health and financial information of the corporate debtor, understands that this transaction is done merely to defraud the creditors, my lords, them participating for a fraudulent purpose.
I'm out of pocket. How am I defrauding somebody? I've already paid that consideration.
My lords,
If you think the corporate debtor has got more than the market value of the property, they've benefited from this transaction.
my lords, that is essentially the point why Section 66 would exist, my lords. The corporate debtor never received the money. My lords, if the corporate debtor would have received the money,
Debt to that extent was wiped off their books.
Indeed, my lords, the wiping off of debt, my lords, would not constitute as a consequence which would further help an insolvency and bankruptcy case, my lords, in this present case, because the other creditors are prejudiced here, my lords. If, so to say, the corporate debtor had taken the
What
money.
is the hit? The hit in terms of monetary terms, let's talk about it. The hit is 2 crore rupees for the
Indeed, my lords.
that you're saying is with an intent to defraud.
Indeed, my
That
lords.
hit has been done on account of conduct of Mr. Valmira. If at all, allegedly, that's all that has been. So his conduct is in question. His conduct to defraud is in question. We don't see any interlinkage between Mr. KCPL because they've already discharged. To that extent, they're already out of pocket.
My lords, with effect to the same, which brings me back to a point that I was trying to make earlier, my lords. Firstly, intent to defraud on part of the promoter, my lords, is proved. Now, when we look at it from the lens of a related party
It's
transaction,
not proved. We are just assuming.
my lords, there's an
For the
end.
sake of question.
My lords,
Say it's proved.
well, the NCLAT order still stands against Mr. Arun Valmera, my lord. Since it has not been appealed, Mr. Arun Valmera judicially stands liable.
That can't stop us from allowing these appeals.
Indeed, my lords. But for my lords to say that Mr. Arun Valmera was not liable for 2 crores was not involved with an intent to
Mr.
defraud, he
Valmira
would
is
have to
not
be a
before us
party.
today. He's not before us today.
Indeed, my lords. Essentially,
We're keeping that aside.
essentially, my
Let's
lords.
focus on KCPL.
Essentially, my lords.
Illegality in that transaction.
Indeed, my lords. So the essential point of the transaction was that an asset of 2 crores was wiped off from the corporate debtor,
I'm
and
asking, is there any illegality in that particular transaction? Is that
Indeed.
transaction illegal?
my lords, the transaction may be legal in terms of property law or in terms of the Indian Contract Act, my lords, but that does not mean that it cannot be brought under the purview of the Insolvency and Bankruptcy Code, my lords. The immediate consequence is that a creditor is left at prejudice, my lords. And if the case may be of the appellants that there is,
How is BOB at prejudice? Can you explain that?
my lords, it is to say that there are other creditors of the corporate debtor that are present in this case, my lords. Bank of Bharatvarsha has merely moved an application for CIFP, my lords. That does not mean that
No,
the
but
other,
who is prejudiced and how are they prejudiced?
my lords, the committee of creditors in this very case would end up getting prejudice, my lords. If a direct inference may be drawn from the proposition,
But how?
my lords, so my lords, Bank of Bharatvarsha is the only creditor with a secured loan, my lords. I mean,
But this land is unencumbered, so Bank of Bharatvarsh doesn't have anything to do with this land.
my lords, I mean, the other creditors who have provided money to the corporate debtor, and my lords, this very asset being moved away and them not getting their dues, my lords, is prejudicial.
But they haven't put a charge on this asset. How are they prejudiced?
Indeed, my lords. It is to say that if the company would have gone into insolvency, my lords, this asset would have been used to repay debts. My lords, that the question is not whether the sale transaction was valid or not in terms of the Indian Property Act or Contract Act, my lords. The sale transaction occurred, and the money that was received from the sale transaction was used to pay off the creditors. The company would have not become an NPA, my lords. The NPA would have been survived, my lords.
No, money was actually used to pay off a creditor.
Indeed, my lords, but that is the essential point where fraudulent intent would be brought forth, my lords, because an unsecured promoter's loan.
The fact remains that Mr. Valmera is a creditor.
Indeed, my lords.
India says that the company has received the money.
Indeed, my lords, but it's a promoter's loan, my lords. A promoter's loan under the waterfall of Section 53 would be paid in the end, especially when it's unsecured loan, my lords. It is important that you discharge all the other loans and then you come back to a promoter's loan, my lords. Now, this is a position which is admitted even under company law, my lords.
Now, let's say we direct that, let Mr. Valmira be directed to pay the money back.
Indeed,
Because that's the only direction that we can pass. KCPL has already paid that money. So now we will say that you consider the COC needs to reconsider KCPL and IEU's resolution plan. The 29AG disqualification, you're not satisfied with that there's any disqualification to that effect.
Indeed, not, my lords. So when we,
Why are you not willing to vote on
My
these
lords-
plans again?
my lords, so the fact remains that the COC has already seen the plans of both IUEL as well as KCPL, my lords. The
But you are
question,
willing to vote on an unsolicited plan. You're saying that we want to only consider the unsolicited plan. We do not want to consider a plan, which we are saying that 29AG is not attracted at this stage.
my lords, 29A would be attracted at
We're saying that we are not satisfied as of now that there is any disqualification under 29AG. If that goes away, then let the COC vote on both the plans. As RP, how does it matter to you?
My lords, but as a successful resolution applicant, it would matter to IUEL.
See,
my lords.
that's where the conflict of interest is.
Indeed not, my lords. And I can explain to the same effect, my lords. When we look at the position of
As a
the...
successful resolution applicant, also that you don't have any vested right today, right?
Indeed, my lords. But for this court to pass an adverse judgment against me, my lords, I would
You
still
talk
have to...
about it as an RP. As an RP, if we direct you, then you will have to place both the plans before the COC to reconsider. We say 29AG is not applicable.
My lords, even in that case, my lords, the COC has already decided after looking at both plans that the most viable plan for it...
That is not right. You rejected the KCPL's plan even before seeing IUEL's plan. You have not compared the plan.
Indeed, my lords. But my lords, the very fact that COC deferred voting after considering the plan shows that the COC decided it was not viable for the COC.
You have deferred not on the viability aspect, you have deferred only on the aspect of the eligibility.
Indeed, my lords. Which is to say that the point that council tries to prove here is that first, the COC has seen the resolution plan, my lords. It only hasn't voted on it, my lords. Secondly, it has seen IUEL's plan, and it then voted on IUEL's plan because it considered IUEL's plan commercially viable, my lords. Which is to say that even if the court does pass an adverse order against the parties and say that the COC process would have to begin again for voting, my lords, the conclusion would remain the same. That COC would...
Look, come to your prayer actually, prayer 2.
Indeed, my lords.
What are you asking this court to direct? Just read out.
Indeed, my lords. And my lords, the consideration...
Just read out the prayer.
Firstly, to dismiss the present appeal. Secondly, to declare that the committee of creditors are empowered to entertain and consider unsolicited
This is
expression
the
of interest.
ruling you are asking this court to give.
My lords, this in the backdrop of commercial wisdom of the COC, my lords, is very important.
COC can act arbitrarily in its commercial wisdom.
Indeed,
In the name
not-
of commercial wisdom, none of the judgments that you have cited say that they can act arbitrarily.
My lords. And the point that the council tries to make here is that they are not acting arbitrarily in this case, my lords.
The ruling that you're asking us to give is effectively in that nature.
Indeed not, my lords.
You're saying that, no, come on, you just read the prayer. You said that it has to consider an unsolicited.
In, my
expression.
lords, in this very case, my lords, it's a position that we're trying to prove, my lords, that in this case, the unsolicited expression of interest that was put forth shall be considered, my lords, because it has to be seen in the view of why the COC was formed in the first place, my lords, or why CIRP process happens.
Is
My
there
lords,
any case law of this court which deals with this question whether unsolicited plan can be considered by the COC?
my lords, at the present moment, the council does not have any case to substantiate the same, my lords. But the logical inference that the council puts forth before this honorable court, my lords, is still
In
clear.
what context you have cited Kalpra Dhanshi in your...
My lords, indeed, the position of law in terms of that, well, in Kalpral Dharamshi also there was an unsolicited EOI that was present, my lords, and the court allowed that EOI to happen. So the position in that matter before the Honorable NCLAT is clear. NCLAT did allow such an expression of interest to move forward. And it is in light of this expression of interest, my lords, that we are seeking this honorable court to rule on this expression of interest, not in expression of interest in generality, which are unsolicited, my lords. Because this expression of interest, if I may receive 1 more minute, my lords. My lords, to answer and go to link this answer in the question that you asked earlier, my lords, of whether the order to send it back for voting by the COC again would be a favorable process or not, my lords. Since the COC has already seen it, since the COC has evaluated both the plans, the decision is clear that they choose IUL's plan as a value
They did not
maximum.
evaluate the plan because it was considered that they are disqualified under 29 AG.
My lords, they just did not vote on it, my lords. That means that the plan was
They did not
entertained by.
vote, exactly. Let
Anyway.
them vote again.
Anyway, my lords, if that was the case, my lords, since they have already seen the plan of KPCL, and after that, when they saw IUEL's plan, if they considered KCPL's plan more viable, my lords, they would not have voted favorably for IUEL's plan. My lords, the position is that if such an order is passed, the CIP process will continue even longer, my lords.
That can only be your imagination.
Indeed, not, my lords. My lords, in terms of a law,
Not the argument at all.
my lords,
If you have said that we are not going to vote on their plan, then you cannot argue whether viability was seen or not.
my lords, to that effect, voting favorably or not, my lords, 30 seconds to answer my lords this question. My lords, voting on that case on the resolution plan would not take away the fact whether the resolution plan has been put forward and considered, my lords. The point still remains very essentially clear in this case, my lords, that they did not want to vote on that resolution plan. That is well within the powers of the COC to do it, my lords. Just because the resolution plan has been tethered, that does not mean that the COC has to vote on it and has to vote on it favorably in this case, my lords. It can choose not to vote on it, my lords.
Thank you.
Since, my lords, the prayer has been read, if my lords may require me to read the prayer. Much obliged, ma'am. It was an honor argument, folks.
The council seeks permission to abuse the dais for rebuttals. Much obliged.
Your Lordship, I'll be dealing with 3 rebuttals. Firstly, that 36A provision not being followed is a question of law that is to be considered, as they have already cited a case of SBI, and it meets all the essentials, and this substantially affects the rights of the party. If the regulations are not to be followed, then what is the point of putting the regulations in the codes itself? And they say that they did that to protect value maximization and to be in the prime bond process. Your Lordship, 4 months passed when the disqualification was incurred on us, which is about 120 days. They still had a lot of days to reissue Form G. They did not do so because they had their prejudice and they wanted to show their arbitrariness towards IUEL's plan. This is also shown by them when the court said that if we give you the order to consider both the plans, they said that we considered both the plans even in the past, but they did not. Lordship, in the 5th para of moot proposition, it is given that the reason for deferring voting was the Section 66 order. That's why they deferred from voting. It is not even that they saw the resolution plan and they considered it, and then they saw IUL's resolution plan and then said that that we do not want KCPL's plan. Moreover, Your Lordship, they have not satisfied us, satisfied the court on the point of connected persons. Your Lordship, herein there are 2 related parties that entered into this transaction, Arun Balmira and KCPL. Your Lordship, for as ArcelorMittal case has already held, for a persons acting in concert and control, and for connected persons also, there should be some kind of control to the business activity of the corporate debtor that is to be present. Arun Valmira has that. KCPL does not have that. Therefore, it does not fall within the category mentioned for connected persons in Section 29AJ. With this, the council concludes its rebuttals. Much obliged.
The answer to the 5 questions that were put forth. Firstly, regulations. The question put forth whether what is the point of regulations if they are not to govern the process, my lords? The point that we're trying to make, my lords, and the contention still remains that regulations cannot be seen as the end law. There has to be some flexibility that has to be allowed for their implementation. This was this court's holding in Shaifuddin as well as PS Panilaved, my lords. The second question, my lords, that there is a prejudice that is involved towards IUEL, my lords. Firstly, the appellants have not made IUEL a party to this appeal, my lords. So any contention with regards to prejudice over IUEL cannot be entertained. Third question, my lords, which was the question of maximization of value. My lords, essentially the entire point of the IBC is to ensure there is maximization of value. If you are saying that there cannot be one particular resolution applicant that can be chosen over the others, and every unsuccessful resolution applicant can then come and knock at the doors of this court for the resolution plan to be brought forward again, for the CRP to begin again, that would, my lords, be against the very proposition and the principle on which the IBC was conducted, my lords. Fourthly, my lords, deferred for voting does not apply anywhere in terms of the proof of whether or not the COC has seen the plan, my lords. The voting will only come after the plan is seen. And lastly, my lords, they provide that related party transaction in here. They establish that control would not be present, my lords, that there is no control. My lords, we are not arguing control. The point of control that ArcelorMittal held was for Section 29AC, my lords, which is not a point of contention in this case. Rather, my lords, the point of de jure control would further hold that both of these entities have controlled each other's affairs, my lords. With this, my lords, we rush the case.
With that, we come to the end of CNNU Carcel National Moot Court competition. Thanking the judges and the appellants, the respondents for the very competitive round. It was a pleasure hosting all of you. We wish that the participants all the best for the valedictory ceremony. Carcel and CNLU is graced by your presence. Thank you.